Chris Lawton. I'm Director of Knowledge Exchange here at Farm Credit East. A couple of things to mention. The recording of this webinar, all of our webinars, past, present, and future, live at farmcrediteast.com/webinars. To access this recording or sign up for future webinars or review past ones, just go to that address. With that, I'll introduce our first speaker, Mr. Andrew Walmsley. Andrew Walmsley joined the American Farm Bureau Federation in 2011 as Director of Congressional Relations. In addition to leading the farm policy team, Andrew is charged with managing energy, transportation, and biotechnology issues for Farm Bureau. His work has provided regulatory relief for farmers and ranchers, along with securing Farm Bureau priorities and multiple pieces of legislation that were eventually enacted into law. Andrew is also chairman of the Agricultural Biotech Alliance. He serves as a steering committee member of the Coalition for Safe and Affordable Food, the Rail Customer Coalition, and is an advisor to the U.S. Chamber of Commerce on their Energy, Clean Air, and Natural Resources Committee. Andrew is originally from Florida and graduated from the University of Florida with a Bachelor of Science in Agricultural Operations Management. He currently resides in Fredericksburg, Virginia, where he works for the National American Farm Bureau Federation. So with that, Andrew, I'll turn it over to you and you can take it away.
All righty, thank you, sir. I guess we'll see, hopefully the screen switch over, but as we do that, appreciate the opportunity to join you all this morning. It's been a little hectic day with a biotech rule coming out today and the president also signing the farm bill this afternoon. So if we could have had a perfect world, I would have gone after Clay to give this presentation, because Clay's really the meat and potatoes, the expert, knows the regulations. But I'm going to hit a couple of high points here as we kind of look at transportation and agricultural issues. My contact information is at the end of my slides. I believe those are going to be available on the website. I will not be around for questions, unfortunately, because of scheduling. But feel free to shoot me an email or give me a call if you have any questions, or if there's something that was confusing or you just quite don't understand. I'll be happy to get back to you. A couple of things we're going to cover today on the webinar is broadly the covered farm vehicle exemption. I'm going to give you a little bit more background of how it came about and the general principles around that. I think Clay might have a little bit more details that he can share, you know, on the carrier enforcement side of things, perhaps what they're looking for. I'll briefly go over the 150 air mile exception that exists both statutorily and some updated guidance that we received from DOT earlier this year. Just highlight a few other high-level ag exemptions that are out there, and then what might be in the future on what we're looking at for regulatory relief when it comes to transportation and agriculture. So the covered farm vehicle exemption, if you are a farmer, I hope you are aware of this exemption. Basically, if you are under 26,000 pounds and you're operating this commercial motor vehicle by a farmer or employee, you're exempt from most of the hours of service and CDL regulations. And then if you are above 26,000 pounds, you are exempt within your state, and up to 150 air miles. If you were to cross a state line from your farm, you would have up to 150 air miles to travel and still utilize this exemption. The key thing on all the exemptions we'll cover today, and what we always reiterate with our members, is while you might have some regulatory flexibility, Congress may have recognized the uniqueness of agriculture due to seasonality, of the perishability of our products. You can never operate in an unsafe manner. So at the end of the day, you have to have a safe vehicle and you need to be operating in a safe manner. So I just want to reiterate, safety is key, but you do have some flexibility as a farmer who can claim these covered farm vehicle exemptions. And I think Clay will cite some of those statutes, and it's in his presentation, so you can look at those. The FAST Act in 2015 kind of expanded upon that, just giving a little more flexibility to states to provide additional relief if there was some type of interpretation issue, or if there was something unique to their agriculture in their state. A state could provide that without facing the penalty of losing federal funding. I don't know how many states have taken advantage of that, but just something to keep in mind to work with your local commodity group or with your Farm Bureau. If there's something in particular intrastate that would fall under covered farm vehicles that you need clarification, your state does have a little bit of wiggle room to potentially provide that relief. One of the other exceptions out there for agriculture, whereas the covered farm vehicle is mostly limited to a farmer or farm employee, those that are actually commercial haulers hauling agricultural commodities can take advantage of the 150 air mile exception. So whereas the covered farm vehicle, you would need documentation, either a farm plate or some type of other registration that's dictated by your state to claim covered farm vehicle status, the air mile exception is a little bit different. It depends if you're hauling ag commodities. And so ag commodities are those that are defined in statute along with livestock. And so if you're hauling those, whether you don't traditionally haul ag, but you're in this case hauling ag commodity or fish, you can take advantage of this exception. And so this exception here allows you within 150 air miles to not worry about hours of service regulations. You are exempt from hours of service regulations. So if you can typically operate from a source within 150 air miles, you do not require an ELD because you do not need to keep logbooks, records of status, rods, 4 hours of service. A clarification we got a little bit earlier this year, which is helpful, is clearly defined what a source is. So a source is not necessarily where you start your workday, but the point to where you first load an agricultural commodity onto your truck. That becomes your source, and that's where the 150 air mile radius begins. If you were to say you're not operating within the 150 air mile radius, you were to leave beyond that, what DOT clarified earlier this year is that the 150 air mile radius still is in effect. You can take advantage of that. So as you're driving within that 150, which is about 172 road miles, you are exempt from hours of service. As soon as you cross over, though, you then are required to comply with hours of service regulations. And if you do that more than 8 times in a month, you would then also have to comply with electronic logging device regulations as well. The other nice thing that they clarified outside of getting that 150 on the front end for ag commodity haulers, say you were to drive 5.5 hours and come back those 5.5 hours from the 150 radius, so you're still within your 11 hours of drive time, you are then exempt on the back end of that haul. So the 150 would then come back into effect once you re-entered it on the back haul if you're returning back to that original source. So a little bit more flexibility, especially those that might be running those sort of distances, but especially those that are running within the 150. That is an opportunity to take advantage of if you're hauling ag commodities. 2 others just to highlight. These are from a few years ago. They were first regulatory, but then they were also put into statute. Those hauling bees and livestock, because obviously we're transporting live animals, it's not the same as hauling t-shirts, do not need to stop for the 30-minute rest break requirement. This is especially, we had concerns especially around this if it was extremely hot during the summer or extremely cold in the winter. You know, a lot of our livestock trailers, same situation with bees. If you're not moving, there's no airflow. So it's 100 degrees out, high humidity. You stop for 30 minutes, it could be a catastrophic situation there with your load. So once again, a recognition both by the agency and Congress to give a little bit added flexibility for those hauling live animals. Switching a little bit of gears now on ELDs. Right now, there is an exemption in place for any transporters who are hauling livestock and insects. You do not need to comply with the electronic logging device mandate. There are some other areas where you may not have to comply with ELDs. I think Clay will get into that. That's back to that 8 days in a 30-day period, the age of your truck. Some of those issues, you have some additional flexibility. But if you're hauling livestock and insects, you are not required to have an ELD. This is tied to appropriations. So we're right now in Washington waiting to see if the government shuts down or not. The Senate has passed a continuing resolution to February 8th. The House might be revolting. The president's supposed to be meeting with House leadership as we speak to see if they actually have a deal on a CR. Either way, I put that all out there because this exemption's tied to appropriations. If there is a shutdown or a continuing resolution, this ELD will stay in place for livestock and insect haulers. Now, when they come to an agreement on appropriations, we had in both the House and Senate passed bills that they had to conference and pass as a final package. That exemption was also in place, and that would have kept it in place until the end of next September. Now that's uncertain because they're not going to pass that appropriations package. So either there's going to be a shutdown or a CR to February 8th, and in both scenarios, this exemption for livestock and insect haulers from ELDs will stay in place. So for the near-term future, that exemption will not be going away. There is no permanent exemption at this point. One of the reasons we worked on this so hard on ELDs, working with the Cattlemen's Association and Livestock Marketing Association, is once again this live animal situation. ELDs really made it difficult to utilize some of the flexibility that some of the other regulations we covered for live animals. And I think it also exposed some challenges we were seeing with hours of service. So we have petitioned FMCSA, Department of Transportation, for longer drive time for livestock haulers and fish haulers and insect haulers. That petition will be published probably early next year. There will be an opportunity for public comment. But until we can work through that with the agency or find some other legislative vehicle to address hours of service, we have been pushing to have this ELD exemption in place until we can make sure we're not impairing the industry unnecessarily because of these ELD regulations. One other issue of note, we talked about Farm Bill briefly, passed both chambers last week, the House and Senate. The President's supposed to sign it at 2:30 this afternoon. Tucked in there was just a little bit of flexibility being expanded upon and clarifying congressional intent when it comes to livestock. So after the Farm Bill is instituted, those ag commodity exemption that we talked about on the 150 when we refer to livestock will now clearly state alpacas, llamas, live fish, and crawfish are eligible and considered an ag commodity or considered livestock, excuse me, under DOT regulations. So particularly in the Northeast, any live fish haulers, we had bait fish haulers down in the Southeast that were getting caught up and not necessarily having the flexibility they needed. Hopefully the Farm Bill clarifies that a little bit where you can take advantage of the 150 exception and any other potential regulatory relief in the future if it's referenced back to ag commodity and livestock. These animals would now be included. I know I ran through a lot. My information will be on the end, but just once again, where do we go from here? Ag's not the only industry that are having challenges with hours of service. There's a lot of complaints. There was a advance notice of proposed rulemaking earlier this fall that DOT put out to seek input on an hours of service change. Farm Bureau commented, a lot of other folks did, but this was industry-wide outside of just agriculture. So is the agency looking at a change in hours of service? That's yet to be clear. I think this administration would be one of the most friendly to possibly do that. So there's a little bit of pressure on them to do that. The other one is legislatively. We're going to continue to look for solutions legislatively in the new Congress, either another 150 air mile exemption on the back end, which is my point there. So you'd have it both on the front end and the back end for ag commodity haulers to help give additional flexibility around hours of service. Or there's other things that Congress might do around hours of service. Not clear if that's going to happen, but those discussions will continue to take place. And one of the major opportunities outside of an appropriations package, what a lot of folks are talking about, where they think Democrats and Republicans might be able to come together, would be around infrastructure legislation. Yet to be seen if that takes hold. There's a lot of talk with Democrats on a new Green Deal. Will Republicans accept that tied to infrastructure? And we're in the age-old issue of how do we pay for it. So something to watch in the new Congress, but typically those are the type of packages where everybody's loading up enough goodies in there to get the votes that there might be an opportunity to address some of these transportation challenges or expand upon them. So with that, I will stop. There is my contact information. I apologize again on the scheduling challenges and running through this quick, but you've got my slides, you've got my contact. I'm happy to follow up with anyone that might have additional questions at some point. Thank you.
Thank you very much, Andrew. We appreciate that. Good luck with your transit over to the Farm Bill signing. And again, for all of our attendees, we'll have his contact information on our website and at the end of this presentation for reference. So with that, Chris, if you could introduce our next presenter.
Sure. Our next presenter is Mr. Clay Eppard. Clay has over 25 years of experience in Department of Transportation and Federal Motor Carrier Safety Administration regulations. He joined the regulatory compliance company named Fleet Safety Services as Vice President in 2003 after working for 13 years as an investigator for the U.S. Department of Transportation. During his 13 years with the U.S. DOT, he conducted over 900 compliance audits and investigations of motor carriers and hazardous material shippers. so he knows his stuff. Clay has a unique insider's perspective of the DOT's both regulations and internal procedures, which rival any found in the private sector. He holds a bachelor's degree from the University of South Florida and is also a U.S. Air Force veteran. So thank you, Clay, for your service there. And with that, I will turn the ball over to you, and you can take it away.
Okay, thank you. Thank you very much. Happy to be here to help everyone understand a little bit about the federal motor carrier safety regulations and the carve-outs for farmers and ag operations. My contact information is there on the first slide. Anyone is very welcome to call or email me after this, or 2 weeks down the road, you're like, what did that guy say again, and what was that exemption? No problem. Send me an email. Be happy to answer your question to help clear anything up if I can. All right. I highly recommend, if you don't already have a copy of the federal motor carrier safety regulations, to get a copy. So for the next half an hour I'm going to be talking about specifically these regulations, which regulations pertain to you, a summary of those regulations, and the farm carve-outs. This highly recommend it. This is for about $20 or less. You can get a management edition. I'm old school. I like the paper copy, the handbook that I can go through. This is also available online. If you search far enough for it, and you can find it online. But I highly recommend everybody get a copy of the Federal Motor Carrier Safety Regulations, because these are the specific regulations that I'm going to talk about, and these are where the DOT rules are. All right. Now, I'm going to do my best not to get too far down in the weeds. I'm certainly not going to talk about all these sections, but I think it's important to know how the regulations work. The regulations are broken down into parts. So as I go through this presentation and talk about these various things, I'm going to be referencing specific parts. So if you had a copy of the regulations, you can go back to this PowerPoint and say, hey, where's that one exemption that he talked about? Oh, that's in 390.39. Well, you can go right to your regulation book and you have it right in front of you. And you'll know, you'll be the wiser, because you'll have the knowledge, you'll have the information right in front of you. You're not just taking my word for it or someone else's word for it. You have that information. Okay. So let's start with this, and then I'm going to get into the exceptions. All right. The FMCSA, that's the Federal Motor Carrier Safety Administration. That is the highway modal agency of the U.S. DOT. So they regulate you guys on this DOT stuff. All right. So the regulations, as we're going to be discussing them, they apply to vehicles single or gross weight of at least 10,001 pounds used in commerce. So if anybody's listening and you do not, I repeat, if you do not operate vehicles which are at least 10,001 pounds single or combined weight, or any size vehicle moving placarded hazmat, nothing I'm about to say applies to you, because you're deregulated. So the DOT deregulates everything under 10.1 unless you're moving placarded hazmat. Okay, so let's go from there. All right. Most states have adopted the regulations, these regulations here, Federal Motor Carrier Safety Administration regulations. They've adopted them with some exceptions, but they've pretty much adopted them in their entirety. However, I just mentioned that the federal DOT defines a commercial vehicle at 10.1, while some states define a commercial vehicle higher than 10.1. So for instance, if you're an intrastate only operation and you never leave the state of Pennsylvania, the rules, the DOT safety rules, apply at 17,001. There's a typo on my part. Pennsylvania deregulates everything under 17.1. So if you're a farmer or what have you, any type of operation, if you are based in Pennsylvania, you never leave the state of Pennsylvania, the definition of a commercial motor vehicle begins at 17.1. Delaware, it's 26,001. Massachusetts, New Jersey, New York, it's 10,001. So anybody listening out there, if you're an intra-state only operation, you never leave your state, it's important to find out, okay, well, at what GVW weight does my state regulate me? So if after this presentation you want to call me or email me, say, hey, I'm out of Oklahoma or I'm out of Maine, when do these rules kick in? I'll look it up for you and tell you. But again, interstate, across state lines, it's 10,001. But if you never leave your particular state, it may be higher than 10.1. Okay. So there are three primary farm exemptions in the regulations. When I talk about the regulations, again, everybody, I'm talking about the federal motor carrier safety regulations. All right. There's three primary ones. One is it's defined as a covered farm vehicle, which we'll define in a minute. One is defined as agricultural operations, and one is defined as a farm vehicle driver. Okay. The most far-reaching exemption is if you can meet the definition of a covered farm vehicle / driver. All right. So if, and then I'll tell you what they are in a minute, what the exemptions are. If your operation meets this definition of a covered farm vehicle, which is in section 390.5, that's the definition of a covered farm vehicle. If you meet this definition, there are some really wonderful carve-outs for you as far as DOT regulatory compliance. But all of these must apply in order for you to be able to utilize these exemptions, okay? Andrew touched upon it. Number one is you got to have a farm plate. So the vehicle has to have a farm plate on it or some other designation that allows law enforcement to ID it as a farm vehicle, okay? It has to be owned and operated by the farmer. You have to be transporting, agricultural commodities, and it can't be a for hire operation. So essentially, you have to be a legit farmer. If you're a legit farmer under this definition, okay, with a farm plate, you can use this covered farm vehicle exemption, which is an excellent exemption. All right, this is what you're exempt from. And this is in section 390.39. This specifically tells you if the federal requirements, a covered farm vehicle as defined in 390.5, which I just mentioned what a covered farm vehicle is, okay, including the individual operating that vehicle, is exempt from the following, okay? So number one is, can I use this covered farm vehicle exemption? If the answer is yes, right? A week from now, I might say, what the heck are those exemptions again? You go back to 390.5 and it defines what a covered farm vehicle is. Okay, so if you're a covered farm vehicle, you're exempt from Part 383, which is CDL requirement, Part 382, which is drug and alcohol. Okay, so you don't have to worry about the CDL requirements, you don't have to worry about the drug and alcohol testing requirements, you don't have to worry about the physical qualification requirements in Part 391, which includes medical cards. You're exempt, completely exempt from the hours of service regulations, and you're exempt from the vehicle maintenance paperwork requirements. Now, as Andrew mentioned, you're not exempt from operating safe vehicles, but you're exempt from having to jump through all the paperwork hoops that the DOT requires. Okay, now where can you use this exemption? I'm gonna go back a slide. Andrew mentioned this briefly. If the vehicle is 26,001 pounds or less, this exemption can be used anywhere in the United States. You could drive from Florida to Washington, over to Oklahoma, back to New England, it doesn't matter. You can use this exemption all over the United States. The rules we just talked about don't apply to you. Now, if you're operating a vehicle single or combined weight more than 26,001 pounds, you can only utilize this exemption within 150 air miles of the farm or ranch with respect to where the vehicle is being operated. All right, so I hope that is clear. So again, this is the most important one, or the most far-reaching one. If you meet the definition of a covered farm vehicle in 390.5, you are exempt from CDL, drug and alcohol testing, driver qualification requirements. all the hours of service rules and the paperwork requirements of the maintenance rules. All right. Now let's go to what if you are a covered farm vehicle, you're thinking, oh, I don't have to do anything. Well, you still have to do a few things. What regulations do in fact apply if I'm a covered farm vehicle driver? Okay. Part 390 and Part 392 both apply. Now, I'm not going to, bore everybody here and go into all the details of what each part says, but if you have a copy of the regulations in front of you, down the road or what have you, you can look at it. But basically, 392 is kind of a catch-all part of the regulations, and that's the driving of a commercial motor vehicle. That's what a CMV is. They're a commercial motor vehicle, such as a driver's prohibited from driving if they're ill or fatigued. Still certainly can't use prohibitive drugs. There's some rules as far as alcohol use, such as a driver can't have consumed alcohol within the previous 4 hours. Somebody might say, wait a second, I thought they were exempt from drug and alcohol rules. Well, you're exempted from implementing a carrier-based drug and alcohol testing program. However, you still can't drive if, certainly if you're under the influence of alcohol or have had alcohol within 4 hours, which is all under this Part 392. Drivers have to still follow local laws, and the driver has to be safe, and emergency equipment still has to be on board, okay? So the thing to remember is you're only exempt from drug and alcohol, CDL, or drug and alcohol program, physical qualifications, hours of service, and maintenance. But these general requirements under 392, farmers are not exempt. All right, so let's move on. All right, another exemption, which many of you have probably heard about, is it's called agricultural operations. If you meet this definition under agricultural operations, you're only exempt from Part 395, which is the hours of service rules. So I guess the easiest way to explain this, if you are a covered farm vehicle, all right, that we just talked about, well, you're already exempt from 395. So what I'm about to tell you, you don't have to worry about this ag exemption because you're already exempt under covered farm vehicle. Now, if you're not exempt under covered farm vehicle, meaning maybe you don't have farm plates, or maybe you have, well, there's some other areas that you don't maybe meet the specific definition of a covered farm vehicle, then you can use the ag exception. But the ag exception in this case, and it's outlined in Part 395.1K, all right, there's your reference. You're only exempt from hours of service, okay? And if you read this first part of the slide here, agricultural operations defined as the provisions of this part, and what the regulations are referring to is simply Part 395, which is the hours of service rules, okay? So the provisions of this part, hours of service rules, shall not apply during planting and harvesting periods as determined by each state, okay? So whatever state you happen to be in, whatever the state determines, right, is the planting and harvesting period within that state, you can use the ag exception, provided you're within, if you see the third bullet there, you have to be within 150 air mile radius of the distribution point. And Andrew mentioned that briefly. You're exempt within the 150 air miles. So then your hours of service clock would start ticking once you got beyond that. So Andrew did touch upon that. Okay. So again, the ag operation exemption is for those that can't use the covered farm vehicle, because again, if you're under the covered farm vehicle, you're already exempt from 395, which is hours of service. All right. Now, the next biggest exception is there's an exception under driver qualification, under the driver qualification files, which is Part 391. So again, if you have the regulation book, Part 391.2 exempts something or an operation defined as a farm custom operation, something defined as a farm vehicle driver, and bees. All right. Now again, you're only exempt from Part 391 under this definition. So let's go back what I keep saying. if you're a covered farm vehicle, which I talked about a few minutes ago, right? You have farm plates and you meet all the definitions of a covered farm vehicle. You're already exempt from most of this stuff already, so you're okay. But if you're not, then you can use this particular definition in order to at least get out of the driver qualification bar requirements. Now let's go down to like the fourth bullet. Let's see, certain farm vehicle drivers. Okay. Now, as much as I try not to get lost in the weeds here, it's sometimes I get there and then I got to pull myself back out. But a farm vehicle driver, okay, is different than a covered farm vehicle. Now, one of the biggest differences, a farm vehicle driver, as defined in the regulations, you don't have to have a farm plate, okay? There's no requirement for a farm plate. So if we've got listeners out there that are not, they don't meet the definition of a covered farm vehicle, which I already discussed, because maybe you don't have farm plates, or maybe some of your vehicles don't have farm plates. Well, you can use this exemption under 391 to exempt your drivers from the driver qualification files, okay? Now, you're not going to be exempt from hours of service. You're not going to be exempt from paperwork of the maintenance. You're only going to be exempt from driver qualification files. So you see how this breaks down? You need to know exactly what your operation is. Again, covered farm vehicle, ag, or farm vehicle driver. What applies to you? And then you go from there. All right, so let's go through this somewhat briefly. Which rules apply at 10,001 pounds? Because remember, one of my first slides is interstate commerce over 10,000 pounds, single or combined weight. All these DOT rules apply to you unless you're exempted out. Now, listening to me and looking at these slides, if there's anybody listening that cannot use any of these exceptions, or part of their operation cannot use any of the exceptions that I just talked about, we're going to talk about briefly what these rules are. So again, at 10,001 across state lines, these are the rules that apply. Company has to have a DOT number. You have to have proper driver qualification files. You have to jump through, about 7 or 8 hoops when you hire a driver to make sure they're qualified, to include a medical card, possibly ELDs, which I'll get into in a minute, vehicle maintenance requirement, hazmat rules, and so forth. So these are the basic rules that are in the Federal Motor Carrier Safety Regulations, which I addressed in about the third slide, part 391, part 392, part 393, and so forth. These are the rules. All these rules apply unless you're accepted, and that's why I wanted to talk about the exceptions first. So for instance, let's go to the next slide. Additional rules that kick in at 26,001 pounds, right? Over 26,000 pounds, driver has to have a properly classed CDL. I say, wait a second, I don't think I thought you said I don't need a CDL. Correct. If your operation meets the definition of a covered farm vehicle, you're CDL exempt. Same with drug and alcohol testing. We go all the way back to that one of the first slides. If you're a covered farm vehicle driver, the drug and alcohol testing rules at a company don't apply. However, if you don't meet that definition of a covered farm vehicle, you're not exempted from a company-based drug and alcohol testing program, which includes pre-employment testing, random testing, reasonable suspicion, post-accident, and the rest of it. And then there's some variety of other rules that kick in at 26,001 pounds. Who requires a CDL? I'm sure everyone knows this, but believe it or not, the CDL rules have been around since 1992, and there's still some confusion about the second bullet. Okay, most people know that if the truck is over 26,000 pounds, the driver must have a CDL. Well, what about a combination? So the definition is the second bullet there. You need a CDL if the gross combination weight, right, is at least 26,001 pounds, inclusive of a towed unit of at least 10,001 pounds. You're like, huh? right? It has to be over 26, inclusive of a towed unit of over 10. So look at the bottom there, my example. If you have a straight truck, that's 25,000 pounds. The manufacturer's gross vehicle weight rating is 25,000 pounds, and that driver is pulling a 9,900 pound trailer. Well, he's at 30. What's he at there? He's at 34,900 pounds. No CDL. Believe it or not, that driver does not need a CDL because it has to be over 26,000 combined, inclusive of a towed unit of at least 10.1. So in the second definition there, their example, you got a 16,000 pound straight truck pulling a 10,001 pound trailer. Well, now he's at 26,001 pounds. The driver's required to have a CDL A. All right. So anybody has any questions about that? Don't hesitate to ask me. I'm not going to get into all the different requirements of a driver qualification file to bore everybody to death here. But let's go back to the carve-outs. If you don't get a carve-out under carve-out, meaning obviously an exception, if you don't get an exception under covered farm vehicle or under a farm vehicle driver, okay, both of which are clearly defined in 390.5, okay? So if you don't get a carve out, all your drivers operating vehicles over 10,000 pounds in commerce have to have a complete driver qualification file, which is 7 or 8 required items. Additionally, there's some specific training for CDL drivers called the entry level training driver. If you hire a CDL driver with less than 1 year's experience, you have to jump through some hoops to make sure that driver's trained, such as has to have specific training for hours of service, driver qualification, believe it or not, whistleblower protection, and sure enough, driver wellness. Now again, if you're covered under the covered farm vehicle requirement, you're exempted from CDL, so this won't apply to you. But if you're not exempted from CDLs and you hire drivers with a CDL with less than 1 year's experience, this is required. I talked about this real briefly. If you don't get a carve out for drug and alcohol testing under the covered farm vehicle, there's a litany of rules and regulations for drug and alcohol testing, and that's in parts 382 and part 40 of that big regulation book that I mentioned. Now, these drug and alcohol testing rules have been around since 1989, believe it or not. But various testing, pre-employment, random, post-accident, so forth, like I discussed. So again, if you don't get a carve out, drug and alcohol testing applies to you. Hours of service. Every driver must fill out one of these. Anybody that drives a commercial vehicle over 10,000 pounds, single or combined weight, has got to fill out an over-the-road trucker's log. Unless, well, number one, unless you get a carve out, unless you get a carve out under covered farm vehicle, unless you get a carve out under transporting ag commodities certain times of the year, planting and harvesting within 150 air miles, those are carve outs. Same as Andrew mentioned with livestock and bees, you get a carve out, right? But if you don't get a carve out, everyone has to fill out one of these unless they meet what's called the short haul radius exemption. So if you don't get a carve out, you got to fill out one of these over the road truckers logs unless you meet this exception. And it's pretty simple. As long as you are keeping a daily time record on the drivers when they start and end their day, if it's a CDL driver, he doesn't go over 12 hours. Non-CDL driver can go over 12 hours in a given day. They can't drive more than 11 hours. They got to have 10 hours off between shifts. And if the driver's operating the CDL vehicle, he cannot operate beyond a 100 air mile radius. And if he's operating a non-CDL vehicle, he can go out 150 air mile radius. So again, these apply if you don't get a carve out. Okay. So for instance, let's say you've got some drivers that don't get a carve out and you're not keeping a daily time record on that driver. Well, if you're not keeping a daily time record, you don't get to use this exception. So by regulation, the driver has to fill out one of these, which is an over-the-road trucker's log. But that's something I can help you with. Anybody has any specific questions about that, I'd be happy to help you. Andrew mentioned ELD exceptions real briefly. Again, if you don't get a carve out from hours of service, you're exempt from ELDs, provided you don't have to prepare paper logs more than 8 days during any 30-day period. Or number 2 there really won't apply to you guys. The third one there, if you're operating vehicles manufactured before model year 2000, ELDs don't apply to you. All right. Real quickly, the actual hours of service rules. Again, if you don't get a carve out, you have to meet the definition of the carve outs that I talked about. If you don't meet that definition of the carve outs, these hours of service rules apply to you. You got the 14-hour rule. A driver cannot legally drive beyond the 14th hour of coming on duty. Okay, what does that mean? 14 hours coming on duty. Is that hours on duty? What does that mean exactly? Well, what it means is, as an example, if a driver comes to work at 6 a.m., an individual who's going to drive a truck over 10,000 pounds, if he starts his workday at 6 a.m., at 8 p.m., which is 14 hours later, he legally could not drive that commercial vehicle anywhere, because you legally cannot drive beyond the 14th hour of coming on duty. Now, there is a 16-hour exception, which I'll talk about in a minute, but that's the 14-hour rule. And within those 14 hours, a driver can't drive more than 11. And then you've got the 60 and 70-hour rule. I hope I'm not getting too far into the weeds here if anybody's not real familiar with these rules. You got the 60 and 70-hour rule, which basically says in a 7-day period, a driver can't drive after having been on duty 60 hours. In any 8-day period, a driver can't drive after having been on duty 70 hours. But again, these rules apply if there's no carve out, right? If there's a carve out, then this is just noise to you because you don't have to worry about it. Rest break requirement, we talked about that a little bit, Andrew did. Here's a 16-hour exception. Remember I talked about the 14-hour rule. Guy starts his day at 6 a.m., can't drive after 8 p.m. Well, 1 day a week, provided the driver's a local driver, he's not out overnight and so forth, 1 day a week, a CDL driver is permitted to extend to 16 hours once a week, and a non-CDL driver can extend to 16 hours twice a week. And I mentioned that 60, 70-hour clock, that resets back to 0 after drivers had 34 consecutive hours off duty. A driver must have 10 consecutive hours off duty to reset his 14-hour clock back to 0. So the earlier example I gave, driver starts his workday at 6 a.m., 14 hours later is 8 p.m. That driver then must have 10 consecutive hours off duty before he could legally drive a commercial vehicle again. So legally, he could not come back to work again the next day until 8 a.m., which would be 10 hours later. Again, you have to have 10 consecutive hours off duty to reset that clock back to 0. Now again, right, I know I keep saying it, but I think it's important. These only apply if you don't get a carve out. So that's why it's imperative to understand your operation, what the carve outs are, and then determine what applies to you. So personal conveyance, I don't know if that comes up much in your industry, where an individual is permitted to drive a commercial motor vehicle, a vehicle over 10,000 pounds, as personal conveyance, and does not go against their time, their hours of service time, as a DOT computes it. Such as if you're commuting in a commercial vehicle, or you're using a commercial vehicle on the weekend to do personal business or whatever, that time does not apply. Vehicle maintenance. So we're back to the carve-out. The only carve-out for the vehicle maintenance paperwork requirement is if you're under a covered farm vehicle, right? If you meet that strict definition of a covered farm vehicle under 390.39, you're exempt from the vehicle maintenance paperwork requirements, which is you got to have records of a preventative maintenance schedule, you got to have maintenance files of all work done, you got to jump through some hoops as far as your brake inspector to make sure that they're qualified. You have to have a written post-trip inspection and so forth, but none of that applies if you get the carve out. But if you don't, all this applies. And there's a requirement for a written post-trip inspection. That's the last bullet here. Daily inspection reports. It's a post-trip inspections. DVIR, which is a driver vehicle inspection report, a daily vehicle inspection report. People call it a lot of different things. There used to be a requirement that drivers had to prepare this written report at the end of their workday every day. Even if there wasn't a defect noted, the driver had to fill out this piece of paper and say no defects noted and sign the report. But now, as of, it's probably been 3 or 4 years, a post-trip inspection, written post-trip inspection is only required to be prepared if a defect or deficiency is known to the driver, okay? So you don't have to do this every day anymore. But again, if you get that covered farm vehicle carve-out, you don't have to do it at all. Pre-trip applies to everybody. Even if you get the covered farm vehicle carve-out, drivers are still required to perform a pre-trip inspection. And the reason that is because the requirement for pre-trip inspections is under Part 392. So when you go to the definition of covered farm vehicle, there's no 392 exception. So the pre-trip applies. It's just kind of common sense. I'm imagining all your guys are doing it as it is. There's just no written requirement. Driver does the pre-trip, does a walk around, kicks the tires, got to be satisfied that the vehicle is in a safe operating condition, and then he takes off for his day. And there's a little bit more on the post-trip. I pretty much already covered that. And hazmat, I'm not sure if this pertains to your industry or not, as far as how much hazmat you might move, but there's something called an MOT rule, which is a carve-out for hazmat. It's called MOT, it's materials of trade. If a company is transporting just a little bit of hazardous material incidental to their operation, a little bit of gas, a couple small cylinders, that's essentially deregulated, provided that you don't go over certain quantities and so forth, and it's properly secured in the vehicle. If anybody moves a little hazmat for whatever reason to work on equipment or what have you, as long as it's, let's say, gasoline cans or fuel oil or what have you, if you have any questions about that, don't hesitate to email me. But there is a material of trade hazmat carve-out that everyone can use if the hazmat is incidental to your operation. Okay, so in summary, I think I did okay on time here. It's 10 till 1 Eastern. All right, so quick summary. All right. For vehicles, single or combined weight of 10,001 or more pounds, right, or any size vehicle carrying placarded hazmat, this is the overview of the requirements, what I just basically covered, right? Driver qualification files. But you might be farm exempt from driver qualification files. You might get the covered farm vehicle carve-out, or you might get the farm vehicle driver carve-out. The farm vehicle driver carve-out, again, is in 391.2, but that only exempts you from driver qualification files. And the farm vehicle driver exemption is the one that you don't have to have farm plates, but you have to meet some other specific conditions to use that. Hours of service, possibly farm exempt, right? You could be livestock, you could be an ag operation, custom planting and harvesting. Maybe you got the covered farm vehicle exemption. If that's the case, the hours of service rules don't apply to you. But if you don't meet those exceptions, it applies. Same with vehicle maintenance, right? You could be farm exempt. Drug and alcohol testing, program, pre-employment, random, reasonable suspicion, post-accident. You get the carve-out under covered farm vehicle, right? But no one else gets it. Hazmat, talked about that a little bit, and so forth. All right, so that kind of gives you an idea. This is basically a summary of what we just talked about. All right, there you have it. I'm going to turn it back over to Chris.
Great, thank you very much, Clay. Before we get into questions, I should mention that we're not here giving specific legal advice. So if this is more general informational only, so if you have a specific situation that you're concerned about, the best bet is to reference the regulations, talk to Clay's company, that sort of thing. because we're not here to, you know, give you a pass on a specific situation based on, you know, because we don't have the full understanding of everything. Having said that, I do have a few questions that have come in, Clay,
yes.
if you don't mind. So one is, I know that a lot of farms have they might have a pickup truck or a dump truck, and they have a refueling tank for diesel fuel for their tractors. Is that placardable, or what are the limits for that? And do you need to have a hazmat endorsed CDL for that if you are driving that kind of vehicle?
There is an exception for fuel oil, as long as it's in a small. How big is the container?
A lot of times you'll see these trucks that have like a permanently mounted tank that might be, you know, 40 gallons or so, or 50 gallons or something like that. It's more than just a portable jerry jug.
Yeah, that's fine. As long as the DOT defines a bulk. It's the oddest thing. BULK. They consider bulk hazmat at 119 gallons. It's a metric thing, but it's 119 gallons. So as long as you're moving fuel oil in a tank with less than 119 gallon capacity, you're exempt. You don't need a CDL. You don't need anything. It just simply has to be a leak-proof container.
Mm-hmm.
And that's in 49 CFR Part 173.150, I think, is where it is. But so again, fuel oil, as long as it's in a leak-proof container and the capacity of the tank is under 119 gallons, it's essentially exempt. And that's only fuel, not gasoline. That's a totally different animal. But fuel oil, you're basically exempt.
Okay. Another question is, what if you have a covered farm vehicle? It meets that exception. You're over 26,000 pounds, and you're driving interstate between states. Do you need an IFTA fuel tax sticker?
I don't know.
Okay, that's fair enough.
Yeah, I don't know. I'd have to.
Specific or technical, and we'll get back to that person that asked that question.
Yeah, that's a good question. I mean, I'm not going to charge him to answer the question for him or her. We have somebody in my office that handles IFTA, and she would know the answer to that question, but I'm not sure if the farm gets a carve out on IFTA for covered farm vehicles. Okay,
fair enough. We want to obviously not give incorrect information, so if we don't know, we don't know. Another question that's come up is regarding, excuse me, I'm just trying to read and summarize this.
Sure.
Okay, I'm chuckling a little bit because I knew this was going to come up. What about snow plowing, given that we're in December? I imagine that a lot of times that's during a declared state of emergency, and some of these hours of service type rules might be, you know, put on hold. But do the regulations specifically address snow removal in any way?
Well, the way the regulations address snow removal is they lob it to the states. If the individual state exempts snow removal, then, like I said, the feds permit the states to do that. When you think about snow removal, that's intrastate commerce. I mean, how much snow removal is across state lines, right?
Yeah.
So the feds have basically punted that to the states. But if a state does not give a carve out for snow removal, the only time they'd be exempt if it was a state of emergency. Certainly and they don't, you know, state of emergencies don't happen often, but you know they do occasionally. You get a bad storm and wherever, and there might be a 2-day or 3-day state of emergency by the governor. But outside of a state of emergency, you'd have to check with the individual state to see if they carve out an exemption for snow removal. And I will tell you this, to my knowledge, most states have not. That most states do require, if you're operating a commercial vehicle now, again, let's say if it's in Connecticut, the vehicle has to be over 18,000 pounds. If it's under 18,000 pounds, it's not regulated. But in Connecticut, if you're plowing with snow in a vehicle over 18,000 pounds, these rules apply to you.
Okay.
Unless a state of emergency has been declared.
Okay. Another question, came up regarding what if you're hauling for someone else's product that's not from your own farm for hire. I imagine that would be, you'd either have to meet that ag commodity exemption, or else you'd be fully covered, right? You'd have to require, you'd have to comply with everything.
Correct. You have to comply with everything, right? Yeah, unless it's some kind of a what do you call it? A lease? What is it? What is that? That co-op that farmers have contractual agreements to do work for each other.
Crop share or
yeah,
share crop.
yeah. Outside of that, that's considered for hire, and you're going to lose the exemption, because the whole idea of the exemption is for farmers, not for hire operations hauling farmers' goods.
Okay, I have another question that you may not know, and that's fine if you don't. We'll follow up with this individual. But New York State's DMV forms say that drivers of covered farm vehicles don't need a CDL, but it also says that the driver needs what's called either an F or a G endorsement. And the asker is a little unclear on how to obtain one of those.
Yeah, all I could recommend there is I would imagine there's something on their website. You could drill down on their website and figure out what those endorsements are.
That's fair enough. We'll follow up with that individual. Another question that came up, and this comes up a lot with like landscapers and things like that, is trailers. Are there specific regulations as far as like the brake equipment that needs to be on trailers that are at certain weight ratings?
Well, these are
surge brakes and whether those qualify.
Yeah, these are really good questions. Again, that goes to each state. Some states require, that's not a federal thing at all. Some states require brakes at 3,000 pounds, some at 1,500, some at 6,000 pounds. So that's states. So what I recommend to anybody that has these specific state questions, contact, and you can get the number online pretty easily. Contact the Commercial Vehicle Enforcement Division of your state. It's usually the state police. The state police are generally the lead agency. So the Commercial Motor Vehicle Enforcement Division of the state police, and you can usually get to them fairly easily. And they're great on answering questions like this, because they deal with this every single day, and they know all the nuances within their state, and they're usually very, very friendly. They want to help you comply. So I highly recommend you do that. When you have these specific state questions like that, especially when it comes to weight and registration, that kind of stuff. Okay.
We're approaching 1 o'clock here, and we want to remain to stay on time, but. We got another question that came in about whether a covered farm vehicle has to be owned by the operator. For example, what if farms work together? Could you borrow a neighbor's covered farm vehicle to haul your own crops, or hire a custom operator to hire your crops, or that kind of thing in a covered farm vehicle?
Okay, let me take my.
Does it have to be owned by the enterprise doing the hauling, or could you use a borrowed or leased vehicle to do that? That is a covered farm vehicle.
Okay, well, this is why it's good to know where to go in the regulations, everyone. So under 390.5 is the definition of a covered farm vehicle. And the second part of the definition specifically says operated by the owner or operator of a farm or ranch, or an employee or family member, or an owner or an operator, I'm sorry, I'm not reading that very clearly. According to the definition, to me, it looks like it has to be owned and operated by the owner or operator of that farm or ranch. Now, if there's some kind of an agreement, an agreement to work together, well, you're kind of, if you're working for each other, well, then I would imagine that's probably going to be okay. But you just want to go to that definition and really get a clear understanding of it. And if anybody out there wants to follow with me on that, I'll be I'll happily banter around with you. Okay.
And we'll just do one last question before we sign off here. On the paper logs versus electronic logs, could you refresh us on what is the requirement of when you can no longer use paper logs, when you have to use electronic logs? Is there a certain like number of days per month you're filling out the log or whatever?
Yeah, what that's all about is if you're, well, the rule says that if you're not required to fill out a paper log more than 8 times in a 30-day period, you're exempted from ELD. So I'll give you an example. Let's say you have an operation where you're not exempt from hours of service. So if you're exempt from hours of service, obviously, this doesn't apply. But if you're not exempt, and you're typically a local operation, you're using the 100 or 150 air mile radius exemption, well, you basically have to violate that exemption in order to, by law, to have to fill out a log, a paper log.
Yeah. So if you
violate
do long trips.
Right. So exactly. So if you do long trips or what have you, or go over the 12 hours for CDL driver, more than 8 times in a 30-day period, you lose the exemption. You got to have an ELD.
Okay.
But if you do 2 or 3 or 4 or even 6, you can do up to 8. You can do up to 8 in any 30-day period and be exempt from ELDs.
Okay, but you still use the paper log and track your hours.
Yeah, you would still need a paper log. Exactly. I'm glad you brought that up. If you're in Pennsylvania and you were going to go over to Ohio or what have you, you're going to go outside 100 air miles in a CDL truck. You don't need an ELD if you do it once a month, but you need a paper log to take with you when you do it once a month.
Okay. So with that, we are going to log off. Again, the recording is available, as with all of our webinars, farmcrediteast.com/webinars. And we thank you very much, Clay, for your time, and Andrew has signed off, but thanks again for Andrew as well. And we will follow up with a couple of questions we weren't able to answer today, and otherwise we are adjourned. Thank you very much for your time.
Thank you.
All right, thanks. Bye.
Bye.